Because may have it.
And in application, the adjournment slip.
Because I
circulate the letter.
Because I actually did try to circulate a letter, but I got informed about the emergency a little late. So I could only circulate it around 1, so it wasn't taken on record. I'm great.
Please, Lordship, this petition is raising a very serious lacuna in respect of a constitutional scheme, particularly in scheduled urban areas, Lordship. Lordship.
So you raise this issue.
Lordship, that is part of legislation.
Issue that you are raising.
Lordship.
Requires legislative intervention.
No, Lordship. In this petition, it is not there. In this petition, I am saying that since there is a lacuna, there is vacuum, till then, because in 2001...
Exclusion or inclusion of an area
Lordship.
within a municipality requires an enactment of law, sir. You can't.
Lordship, that's correct. That's correct. In respect of, Lordship, urban village areas...
Parliamentarian. Why can't you raise this issue in Parliament itself?
Lordship, so far as the legislation concerned... Request is
So
there.
dial the correct number, go to your back to the house, and we hope that you will indulge in some good constructive discussion there,
You can
raise this issue.
You can move a private member's bill. You are absolutely right.
That's
That if there is a upgradation
correct.
of a panchayat to a municipality,
Correct, Lordship.
the representative status as per schedule, the constitution, it gets downgraded.
Lordship.
So that requires a legislative intervention.
Lordship,
You can't do it. We can't.
2 point what I want to submit, Lordship. In 1996, the counterparts of the urban scheduled areas, rural scheduled area, act has been passed, everything is okay.
You are
And
right, act has been passed.
Lordship. And in 2001,
This is it.
Lordship,
So Mesa is there.
Lordship.
Mesa is there. Mesa should come in.
In 2001, it is introduced but not passed.
It is name just introduced.
It's still pending. Since 2001, it is still pending. It was introduced. So what I am praying, Lordship, since considering the backwardness of those areas.
In today's parliamentary democracy,
Lordship.
important legislations are waiting consideration of the parliamentarians.
That's correct, Lordship. That's correct. What I am praying before your Lordship here in this petition, till Parliament enact proper act, let there be certain guidelines, certain directions, so that at least elections can be conducted.
This is not an unoccupied field. It's already occupied by a bill.
Lordship,
Can we give directions which will in effect gave legislative life
Lordship,
to a proposed bill.
once, Lordship, this constitutional amendment came, the 1950 committee renders infructuous, but is still working because there is no enactment.
Pass it and declare it as a law
No, Lordship,
in act of parliament.
that we can't do, Lordship.
That is what you are praying.
But till proper enactment, Lordship, at least there has to be election.
Fortunately for you, you have a very powerful platform.
Lordship.
You are a member of, elected member of the parliament. It's not small thing. You are a public representative and your voice is supposed to be heard. So you raise that voice at the right platform and maybe that others will follow you.
Your
Because
Lordship,
this is
may
an issue.
with the permission of this board, may I submit a submission? Certain
Yeah,
municipalities, urban schedule areas like Ranchi in Jharkhand, Jhabua in Madhya Pradesh, they have the municipality, but they are under the schedule areas. So it is against the provision Article 243 ZC. So, and various fragmented petitions have been filed before Honorable High Court. High Court has, as the interim order, stayed that municipality, but still re-election has been convened. And
That's
which
it.
is not allowed under the law.
He has made a
There-
presentation for the Ministry of Urban and Statement is presented.
Who is a member of Lok Sabha from Banswara, in bracket Rajasthan constituency, seeks the following directions. Seeks the following relief through this petition, Article 32 of the Constitution, purportedly filed in public interest. Next one. We are agreed that the relief in sum and substance, that in sum and substance, the relief sought in the petition falls within legislative domain and it cannot be given to this court to express any opinion in relation thereto. However, we also find from the report that the speaker has made a presentation to so and so ministry, which is stated to be lying pending unattended. That being so, we dispose of this petition. We liberty to the petition to pursue that representation and let the competent authority in the ministry concerned consider the issues raised in this point.
No, in this matter, I'm only asking for notice and not for any interim thing, because in the meantime, the mangroves have been cut. Because the order, impugned order of the High Court is 23rd June, and thereafter it seems the National Highway Authority has already cut the mangroves in those 9 hectares. So I'm praying for notice, and I'll tell you also why that is very, very important here. The broad issue is that
Is there any specific order of compulsory afforestation?
Yes, there is an.
So the issue here is, just take the stick, yeah. Let me just delineate the DTAPA that is pending here before your lordships. Yes,
That on 28th of February 25,
yes, my lord.
there was a report called for. Did anything happen after?
That report has not yet been placed on record in that proceeding.
No, the report is placed on record. In that matter, yes.
Was it otherwise? What we propose to do is the earlier proceedings pending.
Yes,
Where experts have been appointed and reports have been filed.
yes.
So let us see the orders for compensatory afforestation and other requirements.
Yes.
Which MC the day.
No, but here in any case, that's why I said I only want notice, not stay, not any interim relief. But I'll tell your lordships why. Let me just delineate the issue because just your lordships may just appreciate what is the issue. A composite a DT EPA clearance from the Dhanu Taluka Environment Protection Agency, composite clearance is taken for the port project, including the road and rail connectivity. Then a composite environment clearance and a composite CRZ, that is one clearance, is taken for the entire project, including road and rail, in which in both of them, before the DT EPA and before the CRZ and EC, categorical statements recorded and the entire TOR is based on that there will be no forest clearance and there will be no destruction of mangroves. Now, on that basis, the permissions are given. The EC is given for the entire project, including road and rail connectivity, on basis of no mangroves. Now, I'm not on the necessity or anything. Now, after getting all that, the NHAI, which is an agent of the Jawaharlal Nehru Port Authority, independently applies for a clearance for its road connectivity. And in that, they say, we now need forest clearance, we now need mangrove clearance, etc., etc. Will be 9 hectares of mangroves will be destroyed, etc. It is pointed out to the High Court that, look, there is only one EC. There's only one environment clearance and one CRZ clearance, which says no mangroves, no this, no that. They are relying on that. If it's an independent project, they would need their own, NHAI would need its own environment clearance and its own CRZ clearance, if it was an independent project. High Court says there's a letter 2 days before they file the petition to the High Court, they get a letter from a deputy conservator of forests of Maharashtra saying that this is an independent project, not from MOEF, not from the CRZ authorities. A deputy conservator of forest gives a letter. High Court says that letter shows that it's an independent project. If it's an independent project, then where is its environment clearance? Where is its CRZ? They are relying on an environment clearance and a CRZ which says no reduction, no removal of mangroves, no forest clearance, nothing. They gave 5. I'll show that to your lordship. They gave 5 alternative alignments in the TOR, and they said all 5 alignments involve no forest clearance and no forest diversion proposal and no mangroves. They gave the number of trees. They said 10,179 chiku, mango, and wild trees will be cut, but no forest clearance because those are in plantations and so on. They number that, they measure each tree. High Court says after everything, when they went for land acquisition, they found in December 2025, they suddenly miraculously found mangroves, 9 hectares of mangroves. When they counted 10,179, not 10,000, not 20,000, 10,179 trees were counted and put in the EC. Actual number of trees. And they didn't, at that time, they didn't do any survey. So now what will happen is this order of the High Court will be a template for the rail clearance. The next thing will be, because the two lines are running almost parallel as per the plan, the railway alignment.
All said and done, when such a huge port is constructed, well, it has to be connected with land.
No, it has to be connected. They gave 5 alignments with no forest clearance required and no mangrove clearance required. So I'm not on that.
If such a huge port is not connected through railways and through roads, how you?
No, of course, no, it must be connected.
National asset, how are you going to utilize it?
But they've got 5 alignments without that. Apart from that, there's one very important thing here. Let me just place this.
That we have to leave to the experts, and those who are working domain experts know very well better than us. What we must.
No, this is the High Court. Your lordships knows that the High Court, under the High Court judgment of 2018, every mangrove clearance in Maharashtra has to go to the High Court, and now they make a petition to the High Court. High Court goes on the base. Now, in meantime, after the 2018 judgment of High Court, in 2019, a fresh CRZ came to be issued by the MOEF. in that CRZ, mangroves are in category 1A. And mangroves, even the buffer zone of mangroves, if a road is made, it has to be made on stilts. There's nothing to stop them making it on stilts.
That's why we are saying that our concern, your concern, our concern
Yes.
should be ensured that what is the way of compensatory afforestation? Is it only in papers or it is actually at the ground? One.
That's why I'm saying issue notice here, because I want to place this before your lordships. Because they can't move the High Court with a completely false basis.
Verification also necessary from your end, because if you see the composite EC, you are absolutely right. Boat area does not require mangrove cutting. That is one of the conditions of.
Yes.
But with that same EC, Roman I at page 401 says that the proponent shall obtain forest clearance for diversion of forest land as per Forest Conservation Act for the proposed road alignment. So there is.
No, not in the EC. There is no mangrove clearance. Let me show your lordship that what they.
We know the recommendation, TOR, on.
That's right.
Recommendation of on which TOR was issued, there was a clear statement, no mangrove is to.
And in the DT EPA also.
The Taluka EPA also says it is about 100 meters from the buffer zone.
150 meters.
Right.
Yes.
However, these are all recommendatory clearances. Final clearance is the EC. And EC conditions permit two things. A, it puts an embargo or a clear condition that no mangrove clearance for port. However, for road, forest clearance permission has to be obtained, which in fact inerts a possibility of clearance of forest. Whether that forest, under the definition of forest, also 2018 Act include mangrove.
So please read.
And on that basis, we can't say there is a violation of the EC on the face of.
Please read para 14 of the EC and if your lordship, what page is that?
393.
I'm not that page 393.
Right, we have seen that is the recommendation.
No. No, I'm sorry. That is in the EC itself.
True.
Please come to page 393, para 14.
I am talking of the conditions.
Yes. I'll come to the conditions, Lords.
In that, no mangroves will be cut was given as
Yes.
condition.
Yes.
for EC clearance.
Now please see 393, diversion of forest land. The diversion of forest land is required in case of road and rail connectivity pass through the forest land, for which about 86.82 hectares of forest land needs to be diverted.
Yes.
However, as per OM dated so and so, the project proponent has presented 5 alternative alignments and justified that it is technically feasible to execute the project along an alternate alignment in which diversion of forest land is not required. The road will be developed by Morth NHI as per the Gati Shakti initiative of government as a greenfield highway, and land acquisition will be as per NHI Act for highways, and user fee will be collected by NHI. Accordingly, road and rail connectivity is being proposed through alternate alignment not passing through forest land. Now come to 402. Now please see 402, my lords.
Mr. Singh, before you come to 402,
Yes.
come to 401, Roman I.
Yes, 401 Roman I.
What they are
Proponent shall obtain forest clearance for diversion of forest land as per Forest Conservation Act for the proposed road alignment if the proposed road alignment is to pass through forest area. But they gave 5 alignments which are not to pass through.
What we are saying is.
What is the necessity for the High Court?
For the EC is not on the face of it breached if they choose an alignment which goes through forest land.
So
You are now indicating is 402 Roman
24.
Roman 24.
Yes.
And the word is due to port construction.
That's right, but the entire project is known as the port project. Please.
The High Court makes a distinction at paragraph 22 of the judgment that yes, for the port construction, no mangrove was to be removed.
I'm sorry, that is.
For the road construction, there was a permission for removal of forest, which includes mangrove, and because there is compensatory forestation and MCZA has given the permission, we are endorsing it.
Look, I'm sorry. Please see the CRZ of 2019. See that for a moment. Now, they were told that there is no 1A, no part of this project is in 1A, including the road. Now, mangroves come in 1A.
As per
Now, please see what is 1A. How does the CRZ operate for 1A?
contentions before us, the MCZA clearance is in violation of CRZ 2009.
2019, absolutely.
It's your
But
contention.
my
That contention was never raised before the High Court.
no, I'm sorry. My contention is
Don't find that to
no,
be
let us not put
meditated
too
at all.
fine a point on it. Yeah, these points are all raised, but apart from that, let me just point this out. Please see that if assurances are given on oath in writing that this is one project, the port project consists of the road and rail connectivity. Just see that for a moment, right from day one. If your lordship kindly sees if your lordship sees the terms of reference first. The EIA report. Let's come to the EIA report for a moment, Lutz. That is at 255. Connectivity aspect, rail and road connectivity. Do your lordships have that? For any port project, the road and rail connectivity are absolutely essential for the cargo as well as for the vehicular movement. Therefore, the road and rail connectivity discussed in this report are not separate, and it is an integral part of the Vadhavan port project. Then, about 5 lines down, the new port, including the road and rail infrastructure, act as a catalyst for regional development opportunities for the local so-and-so. Then, at 326, biological impact potential of road and rail alignment. Impacted trees are 10,179 chiku trees, palm and other wild trees. This is for the road and rail. And then they say, that page 331, HTL, LTL demarcation and CRZ mapping. 331, your lordships have that? 7.6. And please come to the foot of that at 7.6 at 332. The proposed road and rail alignment for the port connectivity lies in CRZ 1B, CRZ 3, 200 meters to 500 meters, CRZ 3, no development zone, and outside CRZ areas as per approved CZMP. So the CZMP is based that there is no part of it in CRZ 1A. Mangroves are in CRZ 1A. This application by NHAI, which is only an agent. JNPA did not go to the government. The agent goes to the government. The agent has played a fraud ultimately. I am saying that notice must be issued for this. And this same template now will be followed for the railways. We are not against development. We are saying that ultimately they can't mislead the authorities, mislead the courts.
High Court order itself notes that 208 mangrove trees were cut on an area of 9.2 hectares. As compensatory plantation, we are planting 1,33,000 trees over 30 hectares.
We would like to see that which is the area, where is the land where you are doing it.
The High Court notes all that, my lord. Notice is not required. And secondly, my lord, the petitioner here, he's filed an application for permission to file. He was not a party in the High Court. In fact, this petitioner's SLP.
I was heard. My appearance, Ms. Minaz Kakalia's appearance is recorded.
I only said
by the Honorable High Court.
I only said he was not a party. And this petitioner's SLP is pending, in which my lords have already sought the report. Every ancillary order need not be entertained, my lord. Very reasoned order, and we've already paid 4 crores.
They don't even make the project proponent. JNPA has not made a party. I've taken out an IA to make them a party. When they apply to the High Court, they don't make JNPA a party in the petition.
I'll request,
of proportionality. If there you have 5 alignments available to you which don't affect forest, which don't affect, why do you choose one?
That 5 alignment, alternate alignment, that is now history. That is completely irrelevant issue now. The only issue that survived and limited issue we want to examine is the compensatory afforestation path and that expert report on environmental damage return.
Yes.
And then what should be the correctional measures for that,
Yes.
if at all it is there.
There are 2 aspects why we are requesting that notice be issued. One is that this High Court judgment, I respectfully submit, proceeds on a letter. Now, your lordship, my Lord, the Honorable Chief Justice had occasion about a year and a half or 2 years ago in the Isha Foundation case. Same thing. Letters were procured, and on that basis, not the clearance was given. Your lordship said we are not interfering, but we make it clear it's only on the facts of this case we are not interfering, since everything has been done and things have been in place, the buildings have been there for 20 years and so on. Subsequently, those letters and all were struck down by my Lord Justice Gawai's bench. So here again, a letter taken 2 days before filing a petition from a deputy conservator and High Court relies entirely on that to say it's a separate project. But if it's a separate project, it requires its own EC. It requires its own CRZ. That this aspect must be decided, because tomorrow we'll have the problem with the railways. And this will apply as a template in all other matters. And look, permission may be given.
In terms of the findings written by the High Court, as also the expert's opinion, expert's report with respect to the environmental damage effect from a returnable on so and so rate, only for the 2 limited purposes we are.
One is regarding compensatory afforestation and the second
The
one,
other is environmental damage expert report.
we'll file both.
SLP, tag with SLP civil number 24774/2024. List both the cases on so and so date. Then say, accept.
No, the one indulgence.
Accept notice on behalf of so and so.
नाम बताना.
Ame Vikrama Thanvi.
You are for NHI,
Yes.
accept
She's-
notice on behalf of NHI, counter affidavit can be filed. Respect to both the issues mentioned.
No, I also have an IA to implead JNPA, because they were actually a necessary party before the High Court, but they were not impleaded by them.
Not unnecessarily expand the scope, we'll see. Permission grant.
Please, Your Lordship, please.
With great respect, you have to separate the wood from the trees. Let me tell you not similar 2 facts. Page 20. Yes. So, my lord, I am a company. In the year 2007, I took a loan from IDBI. In 2007. I returned it in 2008. That's one chapter. I am not a defaulter. I am not a debtor. So, my lord, when I took the loan, a part of the loan was given by me to a group company. It has been shown in the balance sheet as an advance of a loan to a, my lord, group company. So, my lord, I have not cheated anybody. Nobody has been defaulter, etc., etc. An inspection takes place, my lord, by the ROC in the year 2012. 2012. So they say, well, you have shown it as an advance. It should actually be shown as an intercorporate loan. All right, that's a matter of writing wrong. But it's not a case, my lord, that I have diverted money here and there. Now, my lord, in the year 2019, my lord, a prosecution is launched against the company under 628 of the Old Companies Act. My lord, so I have 2 questions, my lord, to raise. Firstly, my lord, no offense is made out under 628. Secondly, my lord, there is a complete bar, my lord, under 468 of the CRPC of limitation. Have a look at 628 first, my lord. It's a very strange case, my lord. Turn to page 20, page 20, my lord, sir.
Here.
Just, my lord, Justice Bagchi and Justice Mohan. My lord, page 20. First, I will read 628 at the foot, my lord. If in any return, report or certificate or balance sheet, my case is a balance sheet, my lord, prospectus or so and so, any person makes a statement which is false in any material particular, knowing it to be false, or omits, there is no case of omission, he shall be punishable for 2 years. So if I make a knowingly false statement, my lord, suppose I file an affidavit, my lord, that I am not present in the Supreme Court today, I am present in Bombay. It's a false statement to my knowledge. If I make a false statement to my own knowledge, then I can be prosecuted. But my lord, what happened was, your lordship may now turn to page 45.
2012 complaint.
2000, turn to 45.
Part of the report of 12.
This is, my lord, an inspection report of 2012. I am taking it as it is because I am conscious I am not adding or subtracting, my lord, for purposes of quashing. Turn to item 12, Roman 1. Page 45.
Page 45.
Yes, it's a part of the inspection report. Please take it as it stands. Though I have something to say, but I will not, my lord, oppose it. In view of the above, it appears that the nature of payment of 20 crores to the other company is actually an intercorporate deposit, and advances given without interest are not investment. Accordingly, the board minutes do not contain a fair and correct summary and is in violation of 193(2). I have shown it, my lord, as an advance to a group company. Somebody says it's not an advance, it can be treated as investment or whatever. That's a matter of how you, my lord, perceive. But that's not a matter of falsity. I'll show you the actual balance sheet. Give me the balance sheet. You can't be prosecuted for this, my lord. It is my perception.
The finding is, Mr. Ogri, that is, at that time, it was a huge amount, it was not a small amount. You are investing it in the companies owned by a chief minister, and prima facie finding
That's
that all was done for quid pro quo.
Agreed. But that, my lord, is the CBI investigation, CBI charge sheet. It's not a matter of 628. My lord, 628 is the point. We will not prosecute. Sorry?
It's an arguable point in the trial. May not be a case for a
No,
court.
there is no fact involved. The High Court says mixed question of fact and law. This is this is, my lord, I am accepting this statement. I have shown it in the balance sheet. Have a look, my lord. Give a copy. Please have a look at the balance sheet.
Maybe
How is it false?
valid defense for you, but it will be a matter of fact only.
My lord, that's the first question. I've shown it. Second, my lord, in 2012, you are aware? Limitation is 3 years. Have a look at, my lord, come back to page 20. Now come back to 20. How can it go on, my lord, like this? Page 20.
That, Mr. Wadgi, was answered by the High Court.
High Court says it's a mixed question.
No. The reason is 2012, explanation was called for, and
I gave the explanation.
clarity was obtained when the supplementary inspection report.
My lord, I'll show you.
Therefore, the knowledge is being.
No, my lord, I'll show you. Have a look at the explanation called for. See the explanation called for. It was called for at the same time. Turn to page, my lord, 119. 119.
Eventually, you might succeed even on this ground, but this is not that which can be accepted as threshold.
But my lord, what about limitation? It's 3 years from the date of first knowledge.
No, that is Sarah Matthew. If you check Sarah Matthew, there is a 5 judges bench of this honorable court which says how a limitation can be construed for taking cognizance. It's not from the date the magistrate.
I'm showing you 468.
From the date of, you have to read it with 473. You can't read only.
No, 469. My lord, turn to page 20.
T was 473.
Just turn to page 20.
Covered.
My lord, turn to page 20 for a second.
Yes.
I'll come back to, my lord, the explanation. Come to 20.
Where you are writing 468.
468. Now, my lord, kindly have a look. It's very important, my lord. It's very, very important to see 468. 468 says, my lord, except as provided no court, it's imperative. No court, it's a prohibition, shall take cognizance after the expiry of limitation and the period of limitation will not cease. C, 2C. 3 years if the offensive punishable for a term exceeding 1 year but not exceeding 3. In my case, my lord, it is 3 years. Now,
469.
now, my lord, 469 is not quoted. Now, give a copy. Now, see 469. Limitation starts from the date of first knowledge.
There cannot be any deviation from this clause C, 468 to C.
Yes, my lord.
The only question that will be determined based on evidence is that this 3 year will be counted from which day?
So it's 469. I'm very grateful for the Chief Justice question. Now, my lord, see 469, middle of the sheet, my lord.
No dispute over that.
469. The period of limitation in relation to an offender commence either below the date of offense, which is 2008, or where the commission is not known to the person the first day on which it comes to your knowledge. So what is the first day? 2012.
The real chart, actually the
Real.
complaint is in 2018. When the
2018 is not the first date of knowledge, my lord. It's a supplementary report saying the same thing. I show you that.
information provided by you.
My lord, no, my lord, with respect, you can't extend limitation by periodic inspections, my lord. The law is the date of first knowledge. First knowledge limitation runs, it will end in 3 years. Merely because you have a second report which is identical after 5 years, then 10 years, then 20 years, it is elementary, my lord. That can't extend limitation.
In the 12, that in 2012, definitely it was not known that there is an offense, element of offense. According to them, it came to the knowledge
My lord,
only in 2000.
how can that?
If it is 18, then 469 1B will be attracted. And therefore, it will be one of the issue before the trial court, whether it is 469 1A or 469 1B.
And BC 473 also.
Also.
That's what Sarah Matthew says. You cannot read 468 without reading 473.
Correct.
Yes.
Only one more thing now.
That's a discretion
One more thing.
that they have applied.
Just see one more thing, my lord.
Yes.
Turn to 127. 127.
127.
127.
Annexure P5.
This Millard report was placed before the CBI court in the year 2013-14 at 127, at 128, paragraph 4. It is further submitted that one document, letter of ROC, dated 21/8/13, along with the inspection report which I have shown to your lordship, which was collected during investigation, could not be filed with the charge sheet. Same is being filed. This is dated below 2014. Even then it is barred. So you knew in 12, 13, 14, what more is required?
No changes made by 18 report.
By, your lordship may see the report of 2018. There is no change, it's the same thing. I show you that report also.
The comparison, just see it.
Now, I show you, my lord, something important. Kindly, my lord, have a look at this.
This is known to them as a so.
My lord, the words of 2018 and the words of 2012 are identical. Kindly, my lord, have a look at this.
The second report is sought to overcome the time of limitation.
The second report of 18 is verbatim. Verbatim, and it is meant only, my lord, to provide an extension of limitation. It is verbatim. My lord may see, my lord, this chart I am handing over. Kindly have a look at this chart. My lord, your lordship will see. I will read line by line. First 3 lines I will read on the left column of 2012. 3(1)B of the inspection report of 2012. Inspection revealed that the amount of 20 crores was paid and the same was encashed by the company on the same day as evident from so-and-so. Payments were made from IDBI loan proceeds of so-and-so, immediately so-and-so. Now see below the right side, 2018. Inspection revealed it's identical. See 2019, identical. This can't be not extend limitation. This is not a case of evergreening, that you evergreen and go on without with limitation.
Supplementary is called only to overcome limitation.
These are supplementary reports only without to provide.
Mr. Odgi, this ultimately the offense for which cognizance has been taken, that pertains to Messrs Pioneer Power Limited. The 2014 report which you are referring to.
2012. That document, yes.
127 which you are referring. to,
Yes.
That pertains to Penna Cements and its group company.
It's the same company. It's the same company.
It's not
It's
Penna
a-
Cements.
It's a change of name. The same company. So, my lord, there is one holding company, there is one group company, and there is prosecution. It's exactly, that's why I showed you, my lord, this chart which I'm giving you word by word same. How can that be a difference then? And I'll be prosecuted in the CBI court, I can understand. I can't be prosecuted for 628, my lord. 628, I am shown it as an advance, I've shown it as an advance.
Take all this please in the trial court at Rampur proceeding.
Lord, may I make one submission, Lord? Let the trial judge, my lord, look at the issue of limitation first. I don't need any evidence.
From to entertain the-
Kindly consider that.
How the petitioner shall be at liberty to raise all the contentions before the trial court. And the same shall be considered in accordance with law. Yes?
Blind.
That's it.
These people are not interested.
Today the matters are there.
Yes, my lord, so may we tag with the item 30, my lord. Much obliged.
Obliged, Lordship.
The challenge is to the circular, clearly illegal circular, my lord, contrary to the statutory provision. How can such circular be
It's
issued?
been already stated by the,
My lord, the committee, high power committee has said don't rely, but now my lord must stay this. Clearly contrary, on all counts, on all principles of law, this should be stayed, my lord, quashed. Unfortunately, we are council of senior lawyers and advocates passing such kind of resolution, my lord, clearly unfortunate.
has already stated this resolution.
So my lord, my request is not the high power committee has only told the returning officers not to rely.
Trustee.
Lord, deeply obliged.
Who did recognize?
My lords, your lordship's order of 27/7/26. My lords, your lordship had issued notice, stayed the FIR, but directed that the transfer should go on. This is coming on 10th. Lordship may pass the same order and tag it, my lords. In fact, I was not even a party. The others were at least.
Yes, sir.
What?
Very,
Tag with that.
very deeply obliged.
Okay.
Here it's a neat question of law. Your lordships, we did not grant stay. So arbitration, I'm sorry.
Requesting for a pass over, lordships. Item 18.
Then if your lordships can have it on some other day. The question is this. This is, I'm not addressing on merits since the other side is not there. I'm just analyzing, I'm pointing out the question. My lord, this is an arbitration under a state act. The state act provides for remedy of arbitration. The question is, while the other, one of the parties go under the General Arbitration Act 1996, seeking extension of time, can the High Court, which is not having the power of 11, substitute the arbitrator? That is the question of. Your lordships did not grant stay, therefore the substituted arbitrator panel is going on. So there would not be any difficulty on that. But the question is a recurring question, needs your lordship's examination.
No, I'm here. I have to say 2 or 3 things.
No, this will have to be heard, my lord. If your lordships can.
I submit that this should not be heard, at least in this case. The facts will not be shown. Your lordship can leave the question of law open. The reason is this. My lord, my arbitration started in 2021.
He will be on fact.
Before, my lord, a government nominee appointed by them under a state act which is akin to NHAI. So he carried on, my lord. Then, my lord, after reserving, he changed. A second person is appointed. My lord, he reserves, he is changed. Then a third man is appointed. The third man wrote a letter, I have too much burden of my post, government post, I can't do this. So after this rotating, my lord, thing went on, my lord, for 5 years. I moved, my lord, the High Court under 29A, that please substitute now, because I am entitled to compensation for my land, which has been taken away. So, my lord, the High Court then sent it to the District Court because of lack of territorial jurisdiction. And the District Court has appointed a High Court judge. This is, my lord, the facts of this case.
Lord, I am not.
Whether it applies or doesn't apply, my lord, is a different.
I am not,
case
Lord,
of
let my voice also. Lord, I am not urging, my lord, your lordships to substitute and have some other arbitrator. I am only saying, my lord, the question is a recurring question.
decided
that
in some
may be
other
decided.
case, but these are not the facts for a 136 period against my client.
What did he say? Because on 18th May,
Yes.
we made it clear that we already
So
argued.
it's at the final stages.
It is at a final, we are not
Final
disturbing them.
arguments are going on before the judge.
My lord, nobody is, I am not praying that that may be disturbed.
Why do it in this case then?
Question of law open.
Lord, he has to argue question of law someday.
He argued in another case, not this case.
Every time, my lord, it cannot be 5 prejudicial facts.
And
and
it's not a
five
case of
days.
prejudicial facts. This is the case of your own making.
It has to be someday you
Five-
have to
five-
argue.
What your clients have done. This is not a case for 136. For 5 years, I am going on like a bloody round.
Keep the question of law.
Not
open.
for 5 years like this. It's not fair.
We'll examine it
Don't thumb the
in the particular facts and circumstances.
It's only an emphasis. It's all.
emphasis.
Don't wear a ring. It doesn't make a sound.
My lord, sometimes, my lord, I wish, my lord, question of law is also argued
We'll argue
and
another
we
case.
deal with.
Mr. Suresh,
But I am waiting for that case.
it will come next month. I have another case. I will send it to you in advance.
I am waiting for that case, that 5
I will
facts, my
send you,
lord, on
Lord, that's
prejudice.
another case in the
Cannot
office.
be.
The fact
Keep the question of law open. But someday we will have to address on
I
law.
will send you next month, sir. It is coming here. Before this court only. I'll send you. I will send it in advance, Lord.
What is humanly justified in appointing the arbitrator. That part we are informed that the arbitration proceedings are near completion, nearing completion, and documents are being. In light of that, we are not inclined to entertain these special situations.
He left. That's those who come from the High Court, my lord, there are so many things which are so surprising, my lord.
Please, your lordships.
Grateful.
We have kept the question of law.
Yes,
Grateful.
there is a letter.
Item 19, there is a letter.
There is a request, my lordship, but only request, my lord, your lordships may adjourn it, I have no difficulty, but your lordships may fix give a fixed date only, that's the only request. Yes, much obliged.
20 and 20.1, there are two SLPs, my lord. One against the order passed by the High Court and one order passed by the appellate authority, my lord. Now, the question means facts are, my lord, the respondent is a manufacturer of drugs. Now, my lord, they are manufacturing drugs, and two of them, Doc-1 Max and Abronol syrups, my lord, they were exported to Uzbekistan, where 15 kids died.
My lord, with greatest respect, we have to examine the scope and ambit of Rule 85, subsection 3, whether a review would lie or not. Rule 85, sub-rule 3 of the Drugs and Cosmetics Rule 1945. To examine as to whether a review application can be entertained by the appellate authority or not.
My SLP, my
In
lord.
view of no statutory provision, my lord, how the appellate authority can appropriate to itself the authority to review its own order. That is the moot question. First. Second, my lord.
That is an academic issue because now that order of the original authority itself is now challenged.
No, the second question, my lord, on the very same day, without issuing notice to me, an order is being passed behind my back. These are the two important issues, my lord. And then we will come to the fact as to whether the drug qualifies to be under the category which has been projected by my learned friend. There is not an iota of evidence on record, my lord, that the death has occurred due to consumption of cough syrup.
The entire nation has been.
My lord, with great respect, my lord, these observations are harming more to us, my lord, because there is nothing, no material on record.
My lord, there are
I put my head on a platter, my lord. Let him show a single document which links the consumption of cough syrup with the death of the children. I am out of the court.
Not concerned with the death.
Please, my lord.
itself. We are concerned with violation of
Exactly.
the conditions of license.
No condition has been violated, my lord, with great respect.
Ethyl glycol or
Please.
ethyl glycol
Now-
is used in a medicine which is propylene glycol. It's a breach of the conditions of the medicine per se.
With great respect, my lord, there is no violation of any of the condition. I was given the license to manufacture the drug as per the BP standard. I have tested the propylene glycol as per the BP standard. The drug department has tested the propylene glycol by IP standard, my lord. If you are changing the rules of the game in between, I cannot be faulted.
There is no change of the rules of.
My lord can see my license for a moment.
The license does
My
not
lord can see my license for a moment. What are the conditions?
says diacetyl.
My lord, I bow down to that. Propylene glycol did contain ethylene glycol and diethylene glycol. But if I put a question to myself, whether I was mandated to examine that, the answer will be no. Because at no point of time, the BP parameter,
In fact, admittedly, you are a manufacturer of that.
that's correct, my lord, as per the BP standard.
Could not contain diacetyl glycol.
My lord,
This is a medicine, so it's a question of absolute.
no, my lord. My lord, with great respect, this is incorrect perception. My lord, let me clarify that with great respect. I am the manufacturer of the drug which contains solvent as propylene glycol. As per the BP parameter, I am required to test the propylene glycol. I tested the propylene glycol as per the BP parameter, which is found to be in conformity with the standards laid down in the rules. Now the drug department, what does it say, Your Honor? The government analyst what say? It changes the rule. It tested the propylene glycol as per the IP parameter.
Drug and Cosmetics Act, the government analyst's report becomes binding
Binding.
until and unless you take an objection.
My lord, there is a caveat. My lord can see the report of the government analyst. Please see the report of the government analyst.
We are not going to go into the.
No, my lord, but please, with great respect, my lord,
Presumption.
must hear to me. My lord must hear to me.
We will hear you.
No, my lord, see the government analyst report for a moment. We are meeting the parameter as per the BP standards. How come IP parameters comes in between? My lord can see the government analyst report for a moment. Even otherwise,
Just listen, please.
Please.
And to listen also. The first appellate order, which was reviewed by the appellate authority, was palpably illegal.
Illegal.
That order warrants interference.
Please.
The only way to, so that you don't feel that you have not been heard, we set aside both the orders. Appellate original order as well as the
Review order and the High Court order. my lord.
To decide the appeal again after hearing.
Please, my lord.
And till then, the stay will continue.
Please, my lord.
My lord, my only submission would be at this juncture, my lord. The appellate authority has passed an order against me, barring me from producing drugs which having the propylene glycol as ingredient. Abronol cough syrup, my lord, please bear with me for a moment. Docone Max and Abronal. I am not manufacturing, but my entire manufacturing license has been cancelled.
That's a report.
So, my lord, there are 15 other drugs which are being manufactured by me. So, why I am being penalized for a drug which has not been tested by the authority? I can understand Doc 1 Max, Abronol. I put a statement before this bench. I am not manufacturing that.
The suspension of license need not relate to the drug.
Exactly.
It would be in respect of the misdemeanor of the.
My lord, you have only tested two
No, no,
drugs.
no.
My lord, with great respect, my lord, please hear me out.
No.
Two drugs have been tested.
What the Honorable Chief Justice has proposed to you.
My lord, I bow down to that. I am only making a clarification if my lord can permit me to manufacture the drugs other than Ambronel and Docman Max. My lord, I will be raising. I am only invoking the compassion of this honorable court for the woman movement. For the last 2 years, my lord, I am suffering without any fault of mine.
We set aside all the three orders.
No, my lord, with great respect, there is no fault of mine. Please let him show a single document which can link the death to the consumption of cough syrup.
This is merely a triggering point.
My lord,
Glycol cannot contain diethylene glycol. You are fully conscious.
my lord, I am fully conscious. I tested as per the BP parameter.
Ethyl glycol are poisonous.
Poisonous.
My lord,
What are you saying?
please, my lord, please try to understand. I tested as per the BP parameter. I was not supposed to test as per the.
Mr. Singh, if now you have not understand, then it's your bad luck. What can we do?
Lord, we
Our
set-
capacity
You're
has gone.
getting an opportunity to argue.
Please, my lord, we'll do that.
Complete authority.
As well as the. We'll do that, my lord.
My lord,
My lord can give me the right. I will raise all these issues before the appellate authority. No issues.
my lord, we set
For the
all
appellate
three orders, my lord.
Leave granted. We have heard learned relation solicitor of India on behalf of the appellant.
Because I appear for the respondent number 226 plus the state.
Okay.
Respondent number 226 plus is the state supporting the case of the petitioner's plus.
As well as Mr. Dinesh Kumar Goswami and senior counsel on behalf of state of UP.
Milos.
State of UP. Mr. Singh has been heard, Puranam on behalf of the contesting respondent number 1. Next, in our considered opinion, the appellate authority under the drugs and cosmetic.
Please, my lord.
Under the drugs and cosmetic rules 1935 had on both occasions, namely while passing the order dated 11th August 2023, whereby the appeal of first respondent was allowed in part, as well as while passing the review order dated 4th October 2023.
Please, my lord.
Consequently, both the orders are set aside and the appeal filed by respondent number 1 against cancellation of its license by the drug controller, is restored to its original number and file, with the direction to the appellate authority to hear and decide that appeal afresh. It is clarified that we have not expressed any opinion on merits of the case. Next paragraph. Till the appeal is decided by the appellate authority. It goes without saying that until the appeal is decided,
My lord, the cancellation is there, so
Also need to be set aside.
it does not need any qualification.
The order.
The suspension is there, my lord, so we are not manufacturing, so it may not require any qualification.
next paragraph. As a necessary corollary thereto, the impugned judgment of the High Court dated 19th May 25 is also sufficient.
Please, my lord.
I'm grateful, my lord.
Right.
There is a letter. There's a letter.
So, look,
Allow it, please.
So that your main
The main
petition is
decision
pending.
will be heard.
yeah, but I want some variation. I understand.
The interim arrangement will.
No, but I want some variation in the arrangement.
Petition is already stated.
No, your lordships have granted me, my lord, a limited protection. Kindly see, my lord, the last order.
Our protection is that the conviction shall remain suspended.
My lord, subject to not holding an office of profit. I was
You want to hold?
a minister, my lord.
Oh, you want to come back to
My
ministry?
lord, who doesn't want to be a minister?
Yes, the revision decided fast.
My lord, the chief justice is the order.
We'll direct the revision to be heard in 6 months, then you become a
think,
minister.
What a picture. My lord, it's not a case of, it's not a case of. My lord, your lordship will remember, I told my lord the chief justice on that day. My lord, I started as a lawyer, Mufassil lawyer. I said my salary is,
Agricultural income was not disclosed.
I earned 1,000 rupees. So the argument is you can't earn 1,000 as a lawyer when you start. How much else will a lawyer earn in 88 million? So the Mufassil. That's how we learn. These are all political rivals who are doing this.
That was on EWS flats. The case was about your EWS allotment.
And Lord, agriculture income is a large joint family of my father and 4 uncles.
They are saying large tracts of land were owned by you and your family, and you portrayed yourself as economically weak persons.
Milord, 20 people in one joint family, Milord, 4 uncles, father, and us, Milord.
Let the High Court
Very well, but then 6 months, Milord. Otherwise, the tenure will go.
538 of 2025. Filed by the Commissioner against with conviction and sentence by the court below. Pending consideration before the High Court. This is prayer for suspension of the conviction, for staying the conviction, and consequently permitting him to contest the election was declined by the High Court. That the petitioner has approved this court. On 22nd December 2025, while issuing notice, this court issued the following interim directions. Paraphrase. The above stated revision application is still pending before the High Court. You have been elected to us. The petitioner has been meanwhile elected to Maharashtra legislature.
No, I do that. I was already there, my lord.
Already.
I'm already an MLA. I was a minister by virtue of this, my lord. I remain an MLA.
24 you have been elected.
Yes.
Oh, that's already. Then, say, revision petition is pending before the.
My lord, I can only add one thing.
Dispose of this
I had a blanket stay of conviction in the court below,
with a request to the
before the first appellate court.
to decide the pending revision application expeditiously. The interim direction issued by this court on 22nd December 2025, as repeated above, shall continue to operate during pendency of the revision.
My lord may say expeditiously, preferably within 3 months or 6 months. By the end of the year, my lord.
Preferably within 6 months.
I am grateful.
Please, Lordship, this is a.
Yes, we do.
Yes, Your Lordships. Stay, Your Lordships.
Yes, we are.
Stay of the High Court order.
Your Lordship, I'm
Yes.
appearing for the respondents. I'm appearing for the respondent in the matter. Your Lordship, the question is, Your Lordship, the academic session is going on and ultimately, Your Lordship, since we're just looking at, that the matter may be disposed. So, Your Lordship, it may be, we are fine by giving consent to the transfer. The matter may be transferred. All, Your Lordship, if I may.
For you, they are before us, you are asking us to issue a direction in your favor.
No, my lords, I'm saying I'm giving consent to the fact that the matter may be transferred from High Court. We filed this written on 17th April 2026.
Here is a transfer.
Yes, CBSE.
See, Your Lordship's petition.
All right, then
So,
do it.
CBSE has filed a petition.
Say,
There was a matter filed on 1st of July.
You are for the Union of India.
I am for the petitioner R1,
The CBSE.
Ariman Dutt Mathur.
She is the writ petition.
Like counsel for the contesting response number 1 and 2. States that he has no objection if the transfer petition is allowed. And writ petition civil number 5320 stroke 2026 pending before the High Court of Delhi is transferred to this court, to be heard along with the pending cases on the same issue.
May I just make a further request that I was making? Your Lordship, since my petition is first in point of time, the counter affidavit stand filed. Since we filed just 1 week after the, Your Lordship, if this petition could be just, considered as the lead matter, since the pleadings are complete and we're in the third,
That we can't promise that.
it's in the third month of this session.
All these cases
Please, Your Lordship.
make a request on that day when the other matters are also there on board.
Please, my
Now,
Lord.
the others are not here. So you may make that request next time. When the
Please, Your Lordship. So a date may be fixed, Your Lordship. Since it's the third month and the language studying has been stopped. It's been abruptly stopped.
When we will finally hear on that day, you point out, then in view of this, the transfer petition is allowed. The petitions once pending in High Court of Delhi is ordered to be transferred to this court. Track the transfer petition along with transfer case.
Obliged, Your
Well, please, my lords.
Yes,
This is the application filed in T.N. Government's case, my lords, on behalf of the state. That is 88067. Seeking clarification of 2 orders, my lords. In fact, what has happened is, before the Honorable High Court, a petition is pending, which talks about having a permission from National Board of Wildlife mandatory in case mining has to be undertaken within 10 kilometers of Asan Wetland Reserve. Asan Wetland Reserve primarily falls in Uttarakhand, my lords. Now, what happened is, initially there is an order of 2015 of the Honorable High Court of Uttarakhand laying down that as far as the 10-kilometer embargo is concerned, it will be total. There is no permission regarding NBL or not. That happened to be modified by my lord in February 2024, my lords, by order dated.
Where, what is the number of your application? Where is that?
88067, my lords. Of 2025, my lords. Initial one.
Conflicting orders.
No, my lord. What happened is the initial, there is a 2015 order of the Honorable High Court of Uttarakhand.
2/7/2015.
After that, the matter traveled to this Honorable Court. Now, this Honorable Court on 14
Just a
to,
minute, you are state of Himachal.
my lords,
Here is 88067.
my lords.
All right.
Amicus is here.
It's that 10-kilometer issue.
Yes.
Yes, my lords. It's primarily because of that, even Himachal is suffering. In fact,
2025.
I am for Uttarakhand, my lord.
Should be here.
My lord, I could not file any affidavit in this matter, my lord.
in fact,
But in fact, we are agreeing with what Himachal Pradesh is asking as well as what Union of India stand is there. Union of India has filed its affidavit from para 15 to 21. We agree with that.
in fact, they are also agreeing with Himachal, my lords.
Yes. All are in consensus.
Well, it's in fact, the
Because
report-
they are related to conservation reserve. Conservation reserve is different from eco-sensitive zones. So the parameter which is applicable on eco-sensitive zone cannot be applied on conservation reserves.
So that is the
That's the
moot question.
And our difficulty is when Uttarakhand High Court passed order in 2015, we approached this honorable court. Our SLP was dismissed as withdrawn. With the liberty to file review, we filed review. That review was also dismissed. And now all these things were noted in order dated 14 to 24.
You are appearing for union.
For state of Uttarakhand, my lord.
Uttarakhand. So in any case, for Uttarakhand, the directions are final.
Yes.
So where is the question of their contesting anything?
Yes, my lords.
Now, who is
contesting against you? No, my lord, because what is happening is the Honorable High Court, there is a PIL.
This condition is, restraining condition is imposed by this court.
My lords, what has happened is, yes, my lords.
Question is that why wetland conservation reserve? In your state, we also, same condition will not apply as in Uttarakhand.
No, my lord. Yes, my lord. What has happened is on 42 gave a direction at page 139, my lords. If my lord will just have it in the application. Therefore, by way of, if I may please read, therefore, by way of interim order, we direct that no mining activities would be carried out within 10-kilometer radius of Asan Wetland Conservation Reserve without the project proponent obtaining permission from the Standing Committee of the National Board of Wildlife and or MOEF. This is the primary issue, my lords. Now, what has happened is, as far as National Board of Wildlife is concerned and MOEF is concerned, they are saying we need not provide any permission for this activity because
they need to provide because of this order. Where do they say that they will after this order?
My lords, there is a...
This order has mandated them to apply their mind and take a call.
My lords, then may it just come to para 11 of the reply filed by the union.
We will direct, you see, we will help you.
My lords.
We will direct the standing committee on so and so to take a decision on your application.
My lords.
That will help you.
My lord, that's there.
Well, can I just make a submission? Well, we've also filed an IA for modification listed along with state's IA. We appear for those who are carrying out mining in Himachal.
Problem will be solved only when the state's application is.
I bow.
Are only in use of the state. Probably that so we pointed out to you that your application fate depends upon what will happen in the state's.
The state's application. Just on conceptually what my friend had did. For conservation reserves, there is a completely separate regime. Uttarakhand High Court's order is based on old law.
Let the MOEF and the expert committee referred to by this court, they take a call on it. We cannot issue suppose there is a wetland area, wetland reserve area in state of Uttarakhand and also in state of Himachal Pradesh.
It's not in the state of Himachal.
It may or may not be. We are also hypothetically we are saying. Suppose it is in state of Himachal also. Only because by a demarcation line on paper you are divided into two states having same geographical conditions. We can't pass two different orders. That will apply uniformly. That means that the entire Himalayan terrain will be governed by the same set of directions.
Same set of regulations.
The only exception can be that an expert body says that wetland is not in your state.
That's right.
Then only you can be exempt.
Very well.
So for that, let them decide, let them take a call.
Well, at this, I'm just saying, I don't have any quarrel with that proposition, Malaj. At this point, I'm only saying that your lordships in 22 said that as far as the concept of a buffer zone, because the whole foundation is on High Court's order is on 2005 judgment of this lordship, which is subsequently being changed now. In 2005, your lordship said 10-kilometer buffer zone for national parks and sanctuaries. That was diluted to say, no, only 1-kilometer buffer zone, that too for national parks and sanctuaries. There is no requirement for a buffer zone for conservation reserve. For conservation reserve. Now, this is a conservation reserve, which in Wildlife Protection Acts is in lower in hierarchy than a national park and a sanctuary. Conservation reserve at page 259, your lordship's judgment is categorical. There is no need for any regulation of activity outside it.
We are, again, you are asking us to determine a question which is purely a factual issue.
Very well. Then your lordship may direct NBWL Malots to decide a
Check this court on 14th February 2024. Formulated 2 questions for consideration that emanated from the orders passed by the High Court of Uttarakhand and consequently directed that no mining activity would be permitted within 10 kilometers of Asan Wetland Conservation Reserve without the permission of a standing committee of the National Board of Wildlife and Stock or Ministry of Environment, Forest and
climate change.
Climate change. MOEFCC.
Climate change.
Climate change. The direction as contained in para 11 of the said order are to the following effect. एक note है इसमें para 13 है ये basically highlight करके ये direction. Next paragraph. Now, who says that in Himachal also the direction is to be followed?
My lord, there is a PIL pending asking for the directions of Himachal to be, Uttarakhand to be applied in Himachal as well.
That PIL is pending in the
That PIL is pending, my lord, and in fact,
PIL is pending in the High Court.
in the High Court of Himachal, my lord.
Next paragraph. We are informed that some public spirited person have now approached the High Court of Himachal Pradesh seeking enforcement of the above reproduced direction in the state of Himachal Pradesh also. It needs no emphasis that both states are adjoining and there is a continuous Himalayan terrain passing through both the states. It must be in this backdrop that the High Court has been approached. Next, for apprehending that the direction that is issued by this court to the state of Uttarakhand may not be mechanically applied in the case of Himachal Pradesh, that the instant interim application has been moved by state of Himachal Pradesh. So some project proponents of Himachal Pradesh have also separately approached. Next paragraph. May be seen that the restraint on mining activities within a radius of 10 kilometers has been imposed. Has been a restraint on mining activities within a radius of 10 kilometers has been imposed in the case of inverted commas wetland conservation reserve. Inverted commas close fist. Whether such wetland conservation reserve is located in the state of Himachal Pradesh or not is essentially a question of fact to be determined by the expert committee. We therefore direct the standing committee of the National Board of Wildlife or alternatively to the Ministry of Environment and Forest and so on, so climate change to take a specific decision on the request that may be made. You have already applied.
Yes, my lord. In fact, union have already filed an affidavit saying that we do not require permission.
On the application that has already been moved by the state of Himachal Pradesh and determine whether or not there are wetland conservation reserves in the state of Himachal Pradesh. So we may hasten to add that if wetland conservation reserve are found stroke identified in the state of Himachal Pradesh, in that case, the direction issued by this court on 14th February 2024 shall apply in the case of state of Himachal Pradesh also, shall apply mutatis mutandis in the case of state of Himachal Pradesh also. However, if there is no such wetland conservation reserve, in that case, the competent authority shall decide the issue of mining strictly in accordance with it. Is it all? Absolutely.
Let's put
Madam,
some
just
time
one
frame.
thing,
Let's put some time.
The shall take a decision appropriately. Let an appropriate decision be taken within one month.
Wait, so deeply.
Amar, just one thing, at page 121 of the Union of India's affidavit, there is a specific order dated 30th January 23, which says, it is also mentioned that section 29, which provides for consultation with the State Board for Wildlife for activities within sanctuary, and 35(6), which provides similar consultation for national parks with the National Board of Wildlife. Such provisions do not exist in Wildlife Protection Act in respect to conservation reserve and community reserve, and state governments were accordingly empowered to take necessary steps for protection and preservation of conservation reserve and community reserve.
You are trying to argue the case of Himachal Pradesh to...
No, my lord, because there is the regime for entire country, and only we are singled out. My lord.
That direction in Uttarakhand will continue, and if Himachal also has the same kind of reserve, then there will also it apply.
Just one clarification. There's only one. It is in respect of only. It is in respect of only Assam wetland reserve. There are no other wetland reserve. So in your lordship's order, when your lordship dictated it.
Because there the issue was of Assam or Assam.
Yes, my lord.
The same parameter will apply to all the.
Today, this IA which Himachal has moved is also in respect of only that.
Only Assam.
Only Assam. There are no other. This is the Ram.
The order is passed by way of abundant caution. That if there are other wetland conservation reserves, the same principle.
Because that was rejected by another order. I just point out to your lordship. Your lordships have rejected it for all other except Assam.
192, page 192 of the IA.
Because if your lordship see the order of 24th October, your lordships have rejected it for all. I just wanted to point that out. For all other wetland conservation reserves, your lordship said that this regime will not apply. So I just should point out that to your lordship.
Where is that order?
Yes. Kindly see page 6 of my note, 24/10/24.
Yes, page 192 of the IA.
192 of the IA.
That is because they were not declared as community reserves. We have made it clear wherever it is a community or a conservation wetland reserve, Assam will be applied.
Could your lordship see para 4? Just
Yes,
kindly see para 4.
read it out.
We therefore find that it will not be appropriate to lay down universal guidelines so far as restrictions to be imposed in conservation reserve and community reserve. The Union of India has already framed guidelines. So this
we are conscious of we are making a distinction between conservation reserve and wetland conservation reserve.
Okay.
Wetlands fall in a different category. Assam is protected as a wetland.
The Act does not make that distinction. I'm only stating that because as an officer of the court, I'm only saying the Act does not differentiate between wetland conservation reserves and conservation reserves. There is only an issue of conservation reserve. This issue was directly put. In fact, I had argued this and the court rejected my prayer saying it will not apply to the entire country. I had argued that what is falling from your lordships,
Please.
1 minute, can I just complete? What your lordships are now saying is what I had argued before the court. The court rejected my contention, so I just thought I should bring that to your lordships notice. That's all.
That we appreciate it, and we are very conscious of the extent to which we are laying down parity.
Grateful.
It's not that it will apply to Madhya Pradesh.
Grateful.
It's not, it will apply to West Bengal. It will apply to.
In addition, this is a Ramsar Convention site. In addition, this is a Ramsar Convention site under the International Convention. I'm grateful.
Why we are making the distinction? A wetland.
I will only be happy. I just thought there is an order. I should just point out that your lordship.
And see, there is basically no confusion, because the same bench in October reiterates Uttarakhand High Court judgment, so that casual observation of permission being given by the board
Grateful.
is overridden by the subsequent order.
Great.
And we have, as my brother was pointing out, in the case of this Himalayan terrain,
it has to
because there is a geographical line between,
have a different parameter.
there is a contiguous.
Grateful. Great.
Obliged, my lord.
Highly obliged.
And we are coming after lunch.
This application may not on board, this is an application by Tamil Nadu filed in April 26.
In this matter, in this matter.
Not in this matter, separately clear. That, we notice, I'll give a copy. Tell us to go to see.
Hi.
There's one, because I had circulated a note yesterday.
I'll give him a copy.
And that
Because your lordships had directed me to directed the classification of matters. Responses were, despite your lordships passing a peremptory order, responses were received only in 75 applications out of 800. Those 75 we have classified and ready. But I was only thinking, because your lordship said other applications will be deemed dismissed. Would your lordships
those 75 which have been identified.
Some of them can go back, some of them can
produce the say a separate order कर देना. After producing the note submitted by learned Micus as well as by the registry, it is directed that 75 IAs which have been identified so far be listed on so and so date.
Very well. Very well.
My lord, my IEA, my lord, this Tamil Nadu, my lord, it's a project, small irrigation project.
You please.
Yeah, I'll give him a copy, my lord. One.
Get it included in that list. We are coming after lunch.
Great.
One more.
Only in SLP.
Great.
Matter, my lords. My lords, the CBSE matter which was listed last week, my lords had directed it for it to be specifically listed tomorrow. It is not featuring in the main list, my lords. May I just give the last status also, my lords? Had specifically listed for it to be listed on the 5th of August. It's not showing in the main list.
There's a language issue where the children are having the difficulty. They're stuck in the middle now.
Lordship, may I please make a mention?
On 20th August. That's why all matters are being.
The main case had been.
This is the main case.
Main case, my lords. This is the main case, my lords.
Yes.
This is the Yashika Bhandari case, my lords. If I may just present this, my lords, to your lordship. The entire batch was listed.
In fact, next week, I think there'll be a difficulty for the Solicitor General. Your Lordship remembers, he said he's leading some delegation of the UN. So next week may be difficult for them. It was slated for tomorrow, my lord.
20th is not week after next. 20th August is what it is showing.
Yes, my lords.
Yes, but that week, the Solicitor General is not here.
Because he's leading the UN delegation.
Next week.
Available from 10th to 14th is what he meant.
17th onward, he is available.
Even then, there's this urgency we had thought next Wednesday, that's why.
Must have gone only because every day press letters are being filed.
No, that is.
Problem for us.
Right, tomorrow, if it can be listed tomorrow, because, for example,
I can't
children
now
have
promise for tomorrow because now it's too late. Let me see what can I.
Could your Lordship try maybe
My lords,
Thursday?
it can come on Thursday or Friday. My lords, in fact, what is happening is there's so many children who are, whatever subjects they are chosen, that they are not getting taught in. And this new language, they don't have teachers or books at all. So therefore, children are actually sitting in classrooms without a subject teacher or the books being available, and nothing is happening. We're in August, my lords.
Clarified by CBSE probably.
No, my lord, that's for 9th, 10th, 11th, 8th, 9th, 10th. This is, we're talking about 5th.
Class 6 also.
Even class 9, the children are actually spending time doing this without any books, without any teachers. That is the problem. They still have a third language. They are learning advanced chemistry, advanced maths, but at the same time doing this.
And if I may, my lords.
But class 6 is the cutoff class where they choose.
My lords, the relaxation, what it said is that we are providing the relaxation from class 7th onward.
Correct.
But
because
class 6,
that
yes,
is
my lords.
The logic, as we understood, was the choice is made at the class 5 and 6
Yes, my
standards.
lords.
So once you have already in 7, you have already chosen.
Yes.
I think the point that I think we had not made clearly was this, that they've already chosen the languages in 1st, 2nd, 3rd, and 4th. When they go into 5th and 6th, because this new education policy 2020 comes into effect from 2030,
Yes.
they've brought it into effect 4 years in advance. As a consequence, these children now who are in that span, who have finished 3rd and 4th, are in 5th and 6th being told to eschew 2 languages that they've learned 4 years. That becomes very difficult, especially in many of the states, we don't have that many language teachers. 22 languages have to be taught as per this policy.
Right. The bouquet is of 22.
Yes.
But if you see the options,
Yes.
they're mostly in 4 or 5 languages.
But unfortunately, the
But
policy itself requires all 22 to be offered, which is why, I mean, they should have applied their mind better to having such a.
And also, my lords, the
Possible for schools.
It's
across
not. It's
the
not. That's
absolutely,
exactly. That's our
that should not be implemented.
our stand.
Madam, there is a difference of the entire 22 languages on offer and seeing a realistic access of language options
Correct.
across the board in various states.
Yes.
That's what we are saying.
In fact, my lords,
It would essentially be Hindi or any one of the regions.
in fact, my lords, in Kolkata, which we are representing a lot of students of, their language options are Hindi, Bengali, and Sanskrit. But they don't even have the language.
Correct you, in some of the northern districts, it would be Nepali.
You're absolutely
Yes.
right, my lord. But they don't have
Lotships are
books,
right.
my lords.
Varies from region to region, and Mr. Gopal, it would in all come to around 8 to 10 Indian languages.
Yes.
So far as foreign languages are concerned, 3 to 4.
This
Nobody opts for Chinese or
This is what we are saying.
language like
Absolutely.
This is precisely what we are saying.
We
We are
agree with
exactly saying what your lordship is saying, and we are saying, therefore, apply your mind.
And-
How can you suddenly dump this on people in the middle of it?
that's only the spectrum they have given.
No, my lord, unfortunately, no. I wish it were only the spectrum.
Working out the proposal or the policy
Yes.
is what we wanted to do because in the last
Correct.
occasion, I think we were of the view that let us see how the creases can be ironed out.
Yes.
Yes.
And CBS has already done it by relaxing up to class 7. We can take a call on 6 because our understanding was 6 is the standard. at
It's
which
even
you
before, my lords. It's even before. It's
that's-
not at class 6 that it starts.
something like this. They are taught, but from 6 you start a new language.
No, my lords. In fact, from class 5th they start.
Which, yes, if you are exposed to that language, it is comfortable.
Yes.
Otherwise, you start it anew.
I agree. I think maybe we could take your lordships through that to show that actually the cutoff is not 6. It's much before
It is
that.
much earlier.
That's the
It's
problem.
much earlier, my lords.
Some schools class 4, but additionally for class 9th, we are requesting a rollback because 9th is when they're preparing for their 10th.
You may consider it either tomorrow, day after.
Lordship may
If
please
it-
make.
if it's-
We'll find out after.
Very well.
Obliged, my lords.
Harsh and coercive direction from the Honorable High Court. I want to challenge it through the SLP. Now, I'm not insisting the court to take suo motu action. My SLP is ready. All I want from the Honorable Court is to kindly get it listed by tomorrow or day after tomorrow.
Tomorrow.
Janab, the problem is the case is now listed for 11th of August. Now my petition will render infructuous if it would not be heard.
Tomorrow list must be.
Day after tomorrow, please, sir.
We will see.
Janab, the direction is to produce the petitioner before the Honorable High Court through the Commissioner of Police, Gurugram.
File the SLP, just give the number to us and have you filed it?
Yes, it's ready. I'm just going to take a diary.
Go and file, don't make advance booking.
Sir, Lordship is already aware what is happening with me. I was about to mob lynch. The documents are with the Lordship that how my document has been for the legal documents. Kindly at least, sir, I am a single woman. How long I will keep struggling?
We will hear, so nobody will be able to hear unless you file the petition. Go and file the petition, give
Thank
your
you.
number to us.
Kindly list it day after tomorrow. Thank you so much.
File it and cure the defects.
Highly obliged.
Make sure that there is no defect and then we will list it.
Sir, defects should be raised by the DR.
All right.
Sir, otherwise there would be no use of this. And if the Honorable High Courts will pass such directions, then how the police will respect us? They already disrespecting us in all the ways. And you are saying the police to produce me the petitioner before the court. Why there is no direction for the respondent? I am the petitioner. You can dismiss my petitioner if I am not appearing physically.
We will list your petition.
Highly obliged.
Yesterday you should have been part of the delegation. I would have resolved your issue here.
But Janab, the High Court is also under your domain. You may kindly direct them.
Hundreds of lawyers were there yesterday. You should have also been there. He also.
Highly obliged.
Right.
25, just call it. Plus 20. Plus 25 is this issue of data protection. The first direct case that has come to your lordships squarely.
It was filed prior to the DPDP Act.
DPDP Act, but because that there is another statute, and this is the first time the direct case has come to your lordships where allegations are square, admitted in the writ that data is being transferred. Question is what protection you will have. The data is not just transferred to people in India, but financial data goes abroad. Europe, United States, because I have circulated a note last time also, your lordships had occasion to see that note is dated for.
Yes, there is a very comprehensive note you also.
Yes, please. Question is how we apply the principles that your lordships have laid on so far as the privacy is, right to privacy is concerned, so far as data privacy is concerned, my lords. The RBI has filed a response. On the last occasion, the Solicitor General was appearing, my lords.
I'm for RBI. We have already filed the response. I'm for RBI. I have already filed the response, but this note I have not received.
The Solicitor General asked for it, was given to him last time.
It's for RBI.
Yeah, no, the Solicitor General appeared for the RBI last time. So we had given it to him, but I can of course just give it a copy. Just give Mr. Babu a copy. It's directed that it is done. Last order directed that it has already been circulated.
What has been circulated?
It has been circulated to all minutes. In fact, some of the people have even filed their responses to the note. Responses to
March
the.
order notices.
Lordship, we are appearing for. I will file a response to this note also.
I'm appearing for 3 of the CICs. Even we'll have to file a response because there are certain.
India has not filed any. No, but why you are delaying your response? This
No, we have already filed the reply to the writ petitions.
Huh.
The response to the learned amicus's note we'll have to file.
We don't file any response to this note. Note is only for our assistance. If you want to draw some help from the note, you take it, otherwise don't take it.
Very well.
You can submit your own written submissions whenever.
Very well. We'll do that. We'll do that.
I appear for the 4th CIC, Manoj. I'll also do the same.
So, but are you ready? Because this matter, we would like to hear it. There's some important issue touching around the right to privacy. Where is the learned solicitor? Who is the
Malad, I beg to appear for Union, Malad. We have prepared some comments on the amicus's note, Malad, but on the third point, that amicus has pointed out that data is going abroad, Malad. I wanted to compile the data that no data is going outside. There is an embargo. RBI's affidavit is on record, but I would have preferred if your lordships may call it after 2 weeks. We'll assist your lordships with our written note, Malad. Otherwise, our counter affidavits are on record.
Madam Asurya, then do one thing, that whatever is mentioned in the note.
Yes.
And it's not, we don't need a counter note. What you can file a explanatory supplementary affidavit.
Please,
suppose suppose the learned amicus has prepared the note on the basis of some presumption, or he has drawn a inference that this is how data is traveling, or data is being transferred or disclosed. There you can file, you can take a specific stand that it is being done or not allowed.
Please, Manoj. Lordship may call it after 2 weeks, Manoj. We'll be ready and assist your lordships.
Like on the request by the Decent Services of India and other senior scope councils representing the respondents, post this matter for further consideration on so and so date. Meanwhile, Union of India may file additional affidavit if so required.
I'm grateful.
Grateful.
26 and 27.
Your Lordship, I appear for Bar Council of India. In this, we had submitted that sealed cover for your Lordship's consideration regarding the mechanism to be followed for co-option on 14 July. That's with your Lordships.
Because I appear for the Bar Council of Delhi, my lords, I was only informing that our counting is complete and we will be filing a formal status report placing all the details before my lords.
But there are certain applications filed before your lordship. What has happened is nobody is opposing this, Lord, giving representation to the women members. That we have said so in our IA also. But it doesn't mean that the statutory mechanism under section 3(2) should be dispensed with.
Yes.
Because what happens is,